Good morning. I am Nohely Ascencao. I come to talk about civil law. The civil law of the private law that applies to a person, things of relationship and that advance or roles, and the special branch that provide intervals. The civil law include the law of person, which studies both the condition of legal personality and the person considered in themselves. The right of things, real property of right, that studied that things and that goes out well of the real rights that can exist of things. The last of lineage, which studied the right of creator or personal. Family life, which studied the family status and the personal and patrimonial relationship that derive from things. The last succession or hereditary life, which studied the destiny of the elements of the patrimony are personal to the dates of this one.
Hello, I'm going to explain what's the common law and where it has its origins. It was first originated in Europe when in 1066 Norman kings came across the land and started to spread justice, installing their kingdoms and courts. It started firstly when they started to form the case law. And what's the case law? Well, the case law was first formed when someone would come to the court to present their cases, and then the king, according to that case, would give a solution or a rule, but it was specific. So the rule and the case. So that's basically what happened, and this started to form what today we know as the precedent system. The common law wasn't at first defined their principles. So a individual here is very important, which is William Blackstone. He, in the 18th century, started to do some lectures of the yearbooks in the case law at the University of Oxford, and he started to create what we know now as the Commentaries on the Laws of England, and this is actually a book of doctrine that is taught at institutes for scholars in law. Next, we have that these principles have been taking shape and they have been divergent in some countries and lands. For example, we have that the English common law is different from the American common law. And why would it be different if they are both precedent systems? Well, at the beginning, it wasn't just as different as we know now they are. Because in America, if you know that, they were conquered by the United Kingdom. So their laws were imposed to them. But now they have diverged and they have their differences. For example, one of their differences is that in the American common law, they have these states that are inside of the same United States. So they have autonomic courts and they have independent courts, but in the United Kingdom that doesn't happen like that, because in the United Kingdom you have a central court that would know all of the cases that are spread around the country and around the nation. So what else is important? Well, they had something that was called the Curia Regis, and this was a court that existed a long time ago. So it consisted in courts that were mobile. They could move around the country to spread justice. Okay, another characteristic of the common law is that, for example, if we see this bifurcation between the UK's common law and the American common law, UK doesn't have a written constitution. And what's their constitution then? Their constitution is based on principles, customs that have been developing since the Middle Ages and even before the Middle Ages. And in America, or in the United States of America, we have a written constitution which gives more certainty to this kind of system that works with the president. something that's very important to notice and to know is that the common law gives more authority to the judges because they are the ones that create the law and shape the law. They are the ones that give this unwritten constitution, in the case of the UK, the importance that it deserves. And in the case of America, they shape the law. And that's different from the civil law because in the civil law everything is codified and everything is certain. The judges have their path completely signaled by the constitution or by the laws. And in the common law it's not so. One final thing is that in civil law everything is codified. As I already mentioned, in the common law it is not so. Thank you for watching.